Hi everybody, thank you for watching this video produced by CMM Legal Services. We are a elder estate and special needs planning firm located in Andover, Massachusetts, and we represent clients throughout the state. Before we get to the video, as always, we got to go through the legal disclaimer. Here it is, 3 paragraphs long. Please read it as it's very important. But just keep in mind this video was made in August of 2021, so the information that is presented may not be applicable at the time you're watching this. This does not create an attorney-client relationship between you and CMM Legal Services, so please don't send us any confidential information, and please don't use this as a substitute for the judgment of an actual live attorney. Today's video is titled Managing the Finances of a Special Needs Child Approaching Adulthood. And while most of what we're going to be talking about today will focus on special needs children approaching 18, some of what we'll talk about is also applicable to just anybody that's on SSI or seeking to get SSI. So without further ado, let's get into it. Okay, so one of the most frequent questions I'm asked is, at what age should I apply for SSI for my child, or what age should I have my child apply for SSI? And the answer to that is, in almost all situations, you're going to want to wait till the age of 18. Now, if you've seen some of my prior videos or have any knowledge of SSI, you probably will remember that there are significant income and asset limitations in order to obtain SSI. And when a special needs child is under 18, not only are they going to look at whatever assets that the special needs child may have, but they're also going to include a portion of that special needs child's parents' income and assets. And that almost always sets them over the limit. And that's why it's generally advised to wait till the age of 18 to apply. Once a special needs child is 18, the parent's income and assets no longer apply to the child. Now, there are some rare exceptions. If a child were emancipated, or if they lived in a residential school and they could get Social Security to no longer consider them dependent on their parents, they may be able to get SSI benefits, but it's very difficult. So in general, you want to wait till the age of 18. And just as a quick reminder, and as I've noted in my prior videos, there are really strict asset limitations. And that strict asset limitation is no more than $2,000 of total dollar value assets in an SSI recipient's name, either at the time that they're applying or any time thereafter. At any time that the amount of assets a individual in SSI totals more than $2,000, what's going to happen is SSI is going to stop benefits for that month, and they're going to stop benefits for any future month until those assets are brought below that $2,000 limit. And just as a side note, if SSI doesn't catch it right away, and 3, 4, 5, 6 months later, they finally see, oh my goodness, this person's assets are well over $2,000. They're not just going to stop benefits when they find out, but they're going to make you repay all of those months that they didn't notice. And that can be a pretty scary thing to get in the mail. And managing the $2,000 asset limitation is probably one of the biggest challenges for individuals who are assisting disabled individuals or their disabled child to manage and maintain those SSI benefits. And here are a few examples of the types of assets that will count against that $2,000 asset limit. Checkings and savings accounts, savings bonds, UTMA accounts if your child is over the age of 21, stocks, mutual funds, bonds, other securities, and child support payments. Yes, that's right, child support payments, and we will talk about that a little bit later in the video, but I just want to also point out why I put exclamation points next to savings bonds. And that's because this is one of the most often overlooked assets that parents who have a child that is of special needs, who's approaching 18, parents often forget about these savings bonds. And if your child has savings bonds in their name, at some point the SSI is going to get word from the Treasury Department. And if that puts them over the $2,000 limit and they've been receiving benefits for months, then they're going to have to repay all of those benefits and get rid of the savings bonds to bring the asset limitation down below the $2,000. So you really want to try to get all the savings bonds cashed in before either they reach age 18 or they apply for SSI benefits. And here's a list of some of the assets or what they call resources that do not count towards that $2,000 limit. And those are one vehicle of any value, a house or a primary residence, personal property of normal value. We're not talking about fine works of art or valuable family heirlooms or anything. Medical equipment, an UTMA account if your child is under 21, anything in a 529 educational plan, anything in an ABLE account so long as it's not over $100,000, and anything in a properly drafted and properly managed special needs trust. So now let's talk about some of the items that were on that list of things that don't count. And the first thing I want to talk about is what's called an ABLE account, or an Achieving a Better Life Experience account. And what ABLE accounts are they essentially are savings accounts, but they're only available to individuals who are disabled and were disabled before the age of 26. Now, what an ABLE account does is it allows a disabled individual to have savings of up to $100,000 without any of that money counting towards that $2,000 asset limitation. Now, as I mentioned, the limit on how much you can have in an ABLE account at any one time is $100,000. And much like if you exceed the $2,000 limit without the ABLE account, if you are over the $100,000 asset or limitation for an ABLE account, then SSI is going to stop your benefits just like they would if you were over the $2,000 limit. And you will not be able to get any future SSI benefits until the account is brought below the $100,000 limit. Now, parents are able to manage their special needs child's ABLE accounts for them if they're not able, or the special needs child can manage it on their own if they're capable. It really depends on the particular situation. Now, with an ABLE account, it allows contributions from any source up to $15,000 per year, and the funds that are deposited in the ABLE account are allowed to grow tax-free, and they are to be used for disability-related expenses. And this is a pretty broad category of things, but it includes education, transportation, medical equipment, employment training, personal support services, and the list goes on and on. Now, one of the biggest drawbacks to an ABLE account is in order to open an ABLE account, the first beneficiary of that ABLE account when the special individual dies is going to be SSI. It has to be SSI. Now, SSI is only going to seek reimbursement for what they've paid out, but if you can imagine a lifetime of SSI benefits or multiple years of SSI benefits is going to add up to a lot of money. So that's one of the biggest drawbacks of an ABLE account. But otherwise, it's a pretty good tool for helping individuals who have been disabled before the age of 26 to have some extra money to pay for some of these disability-related expenses they might not otherwise be able to pay for. The Uniform Transfers to Minor Act and the Uniform Gift to Minors Act, otherwise known as UTMA and UGMA accounts. Now, these are really popular savings accounts for a lot of parents because they're really easy to open and they're available to any child. They don't have to be disabled. And what this account is, it's a savings account for when the child reaches adulthood. Now, a lot of people use it as a college savings plan. Others use it for other reasons, but it's basically intended for the benefit of the kid once the kid reaches adulthood. Now, while they're very, very similar, there's some slight differences between the two accounts. So the UGMA, or the Uniform Gift to Minors Act accounts, are limited only to cash, securities, and insurance products. Now, the UTMA account, on the other hand, is a little bit more wide-ranging in that it can hold not only tangible, but also intangible types of property or assets. And these can include things like real estate, fine art, intellectual property, things of that nature. Now, both of these accounts are considered custodial accounts, and that means that they're accounts that parents manage in the best interest of their kid for when they reach adulthood. Now, the custodians have a fiduciary duty to manage the funds in a manner consistent with the kid's best interest, and most parents are going to do that anyways. And the withdrawals from these accounts are tax-free if they're used to directly benefit the child. And by directly benefit the child, that means things like paying for the summer camp, paying for school tuition, paying team sports, uh, Boy Scout, Girl Scout dues, those types of things. They're not, however, available for things like a trip to Disney World. It has to be a direct benefit to the child, not a direct benefit to the entire family. Bummer. Now, as popular as UTMA and UGMA accounts may be, there are some pretty significant drawbacks to these accounts. The first one is that the earnings in these accounts are taxed. Now, generally, parents or the custodians of the account can include the earnings from the UTMA or UGMA account on their own tax return, as long as they don't total more than $2,200. But if it's more than that, then an income tax must be filed for the minor child, and it's going to be subject to the kiddie tax. So that's a pretty big drawback to these types of accounts. Some of the other potential drawbacks of UTMA and UGMA accounts include the fact that gifts or deposits put into an UTMA or UGMA account are irrevocable gifts. You can't get them back. So once they're in there, that's it. Now, as I mentioned earlier, the UTMA and UGMA accounts are savings accounts for a child until they reach a certain age. And once they reach that certain age, these accounts have to be closed with all the money going to the child, no strings attached. And in Massachusetts, the age that occurs is 21. Now, another drawback to this is that anything in an UTMA and UGMA account are going to be assets attributable to the person when they're applying for federal financial aid for college. So that may be something that you want to keep in mind if you have one of these accounts and your child's going to apply to college. Now, in terms of special needs individuals, the reason that UTMA and UGMA accounts can have some pretty big drawbacks is, they work great from whenever you open it until the child reaches the age of 21. Now, if your child is going to apply for SSI at the age of 18, SSI is not going to count anything that's in the UGMA accounts until they reach the age of 21. And once they reach the age of 21, then anything that's still left in those accounts are going to be considered assets of the SSI beneficiary, and that's going to throw them off of their benefits. And it can be a risky thing to have, and parents or individuals may not realize that could impact the SSI recipient's benefits. But if Social Security doesn't notice these accounts until months and months later, they're going to send you one of those letters asking for thousands of dollars back, and you just don't want that to happen. So just be careful as the child reaches 21 and figure out a way to not only close the account, but get it into another type of account that will not impact their eligibility for SSI benefits. Okay, let's look at qualified tuition plans, otherwise known as 529 plans. Now, a lot of you may have heard of these types of accounts, but basically for those who haven't, what these accounts are, they're educational savings accounts. And they're accounts where individuals and family can contribute money into the account. That money can grow tax-free, and so long as it's withdrawn for an educational purpose, it can be withdrawn tax-free. Now, 529 plans were initially aimed at paying for future college. However, it's now expanded to where you can pay for things like private K through 12 or apprenticeships, as long as it's education. Now, 529 plans are not going to be counted as a resource going towards that $2,000 SSI limit, so long as the 529 plan is in the name of the parents or the guardian. If you have a special needs child and you have a 529 plan in their name and not in yours, you should try to make some changes to get that fixed, because if it's in their name, once they reach 18, it's going to be considered an available resource. So there are no limits on the amount you can contribute to a 529 plan, but keep in mind that any deposits over $15,000 per year for an individual, or $30,000 per year for a married couple, anything that's contributed over those amounts are going to be deducted from their lifetime gift tax exemption, which currently stands at $11.7 million. So it's pretty high, but keep in mind that's very subject to change depending on the political winds. But as of September of 2021, $11.7 million is the lifetime gift tax exemption for everybody. Another great feature of 529 plans is the fact that contributions can be front-loaded. Now, what front-loading means is it means you contribute a large sum of money all at once, and rather than having to deduct the whatever is in excess of your annual gift tax exemption from your lifetime gift tax exemption, you can stretch that annual gift tax exemption out over a 5-year period so that as long as you don't contribute more than $75,000 at that one time, you're not going to have to take any additional deductions from your lifetime gift exemption. Now, as I mentioned earlier, withdrawals from a 529 plan are tax-free if they are used for educational purposes. But in the event that a withdrawal has to be made for non-educational purposes, you're going to get hit with a 10% penalty tax. Now, another great feature about 529 plans, at least in terms of how they can work for special needs individuals, is funds in a 529 plan can be rolled over to an ABLE account tax-free. Now, one of the other great things about 529 plans is the fact that they're flexible in terms of who the beneficiary is for that plan. And these plans can be transferred over to another relative, like a sibling, if needed, or something like along those lines. But it's very flexible in terms of who the beneficiary can be. So now, any funds that are rolled over from a 529 plan into an ABLE account are still going to be subject to that $15,000 a year contribution limit that is imposed upon anybody who has an ABLE account. So I believe one of the greatest things about a 529 plan is that it allows you to hold on or basically save money for a special needs individual in excess of that $15,000 a year in some sort of savings vehicle that you can use down the line should the special needs individual need more contributions. Now, if you remember from earlier, one of the drawbacks of an ABLE account is the fact that once the individual who has the ABLE account passes away, anything that's left in it is going to be subject to a state recovery from Medicaid or SSI. What's great about a 529 plan is that that's not true for a 529 plan. 529 plans or funds within it are not subject to a state recovery. So it allows you also to not only basically contribute funds when needed, but limit the risk of estate tax recovery taking too large of a bite into the money that you've saved for your special needs individual. Lastly, a special needs trust is an excellent savings vehicle for special needs individuals. But the special needs trust can only work and not be applied to the SSI $2,000 asset limit if it's drafted in a very particular way. So these types of special needs trusts are great because they work a lot like an UTMA account, but they're available to individuals who are over the age of 21. Now, again, it has to be a properly drafted SNT. So this isn't something, in my opinion, you should go online for to try and do it yourself. It's not worth it because there are very strict guidelines that SSI imposes on special needs trusts in order for them to be considered non-available assets. Now, as I mentioned, SNTs really do need to be drafted carefully so that they can comply with Medicaid and SSI rules about these trusts. But just to kind of give you an idea of some of the requirements, a special needs trust that won't count against the $2,000 asset limit has to be an irrevocable trust. And what that means is the person who set it up or the person who funded the trust or what's called the donor or the grantor will have no additional access to those assets once they are in the trust. It's irrevocable, and that means they have no control, no say, no nothing about any of the assets that are in that trust. Moreover, the beneficiary of the S&T can't be the person who decides when those funds are going to be distributed. It has to be an independent trustee who manages the funds and will distribute the funds in his or her discretion. Now, another thing about special needs trust is much like an ABLE account, in order for it to qualify as something that won't count against that $2,000 asset limit is Medicaid, Mass Health, SSI has to be the first beneficiary of that trust upon the death of the beneficiary. Lastly, let's talk about child support payments. Yes, child support payments count against your special needs child in terms of their asset limitations and whether they meet the $2,000 limit or not. Now, this is because the way SSI looks at it is that child support payments are income of the child. And so even if it's given to the parent directly or guardian directly, it's still going to be considered income attributable to your child, and therefore it's going to count towards that $2,000 asset limit. Now, don't fear, there are some strategies that can be implemented to avoid the impact of any child support on an individual's SSI eligibility. One of those is instead of your ex paying you X dollars a month, they could maybe they could pay for very specific bills that might total the same amount, but they're paying a company directly rather than the child. You can also go to court and try to get the judge to change who the child support payment needs to be paid to. I've heard of some individuals trying to have these child support payments payable to an S&T trust or to an ABLE account. So there are strategies, but just keep in mind that child support payments are something that you're going to have to deal with when your special needs child is reaching the age of 18 and applying for SSI benefits. Well, that's our video today. I want to take a second to thank you for watching this. And as always, if you have any questions or concerns, or you think CMM's Legal Services could help you with your estate planning or your special needs planning, please don't hesitate to either give us a call, write us at our email, or check us out at the web. All the information is right there at the bottom. I hope you all have a wonderful rest of the day or night. And until next time, thanks.